Welcome to Chapter 2 of our materials. Now, over the course of the next 2 or 3 weeks, we will be studying the topic of equitable relief and injunctions. You may recall from my very first clip that we identified one of the 3 key purposes of remedies as providing relief as justice requires to protect legally recognized rights. And we emphasized in that statement of purpose 2 words in particular: relief and rights. For relief, I gave as examples the following 5 types of remedies: equitable relief, legal relief, restitution, punitive damages, and attorney's fees. We begin our exploration of these 5 types of relief with the general topic of equitable relief, and with a particular focus in Chapter 2 on injunctive relief. As you will read in the text, and we will see in later chapters, there are many other forms of equitable relief in addition to injunctions, such as constructive trusts, equitable liens, accountings, to name just a few. But there is no question that the primary form of equitable relief is injunctive relief, and so we will focus our attention there for the time being. There are 2 basic types of injunctions: permanent and provisional. A permanent injunction is entered after a full trial on the merits and is intended to be one of the final orders on the merits in the case, an order which finally resolves the dispute between the parties. A permanent injunction will contain terms directing the defendant to refrain in the future from taking some action, or directing the defendant in the future to take some action. It is permanent in the sense that, absent a motion by party for modification or termination in light of changed circumstances or compliance, the order is intended to be the trial court's final judgment. Courts can also issue provisional or temporary orders that are intended to govern the conduct of the parties for certain defined periods of time and are not intended to be the court's final judgment. The 2 types of provisional orders that we will study are temporary restraining orders, or TROs, and preliminary injunctions. A TRO is intended to govern the conduct of the parties for a very brief period of time, usually from the date of filing of the complaint until a hearing can be held on a subsequent motion for a preliminary injunction. That may be held in as little as 20 or 30 days later. A preliminary injunction, if granted, is intended to govern the conduct of the parties until the end of the trial, when the trial court will make that ultimate decision whether to issue a permanent injunction. So, a preliminary injunction may govern the parties' conduct for 1 or 2 years or more, depending upon how long it takes to get to a full trial on the merits. But before we get into the details of the standards for securing a permanent or provisional injunction, we are going to begin with a review of some history and with a general exploration of the relationship between equitable remedies and legal remedies. As you will see, the law has developed so that there is a general preference of legal remedies such as damages, and equitable remedies are generally available only when the legal remedies are judged to be inadequate for one of any number of reasons. So, time to go back to the reading, and I'll see you again in a few pages. Ciao for now.